1994, 5. January the 1st, 1995, and the time is 10 a.m. I want to show you this. There's 2 cars parked in 1 parking space. This is apartment 3B. This is the same thing that was done at Thanksgiving, and I believe at Christmas. This is not right. That's the 2D car, that's just right. This car should not be here. And this is a visitor car. Both cars are from New Jersey. And that's apartment 3B right there, kitchen. First window that you see. Happy New Year! Happy 1995!
Good to see you, Merrill.
Our great niece and great nephew came.
Really?
And we went out for dinner over in Mamaroneck.
Oh.
Well, how are they, your great niece and the great nephew? Are they?
Her father is Merrill's nephew.
Her father is Merrill's nephew.
Yeah.
Oh, that's great. Where do they live?
Down in Pinehurst Avenue. Do you know Pinehurst Avenue? Near the George Washington Bridge.
They have an apartment there.
Oh.
On top of the bridge.
Oh, I know what you mean. Yeah, right. I see.
And they got if you call them, they got a switchboard. They have a switchboard in their apartment.
Oh.
And they don't have anybody to operate. They have to punch certain things.
It's all mechanical. You know, mechanical voice says to do this and do that and punch this and punch that. You can't talk with anybody.
No, it's awful, and you need a touch-tone phone.
Well, Ann says her aunt from Minneapolis can't call her either.
Oh.
Because she's got the rotary phone too.
How did your people look, Merrill? Do they look good?
Good, fine.
Oh, sure. They left us to go up to Albany.
Oh, really?
To a New Year's Eve
Really?
affair. And they're going to stay. Help yourself to some.
Had a crowd in church, did they?
Yeah, they had
Very
a good crowd.
Yes, very good.
Charlie was all right. He's off to Vermont again today, huh?
Yes.
Well, I just asked him.
Yes, he is.
They have snow up there, and he's going to call and the rain that we got was snow up there.
It was?
So he's going to call and see if maybe they should wait a day before they go back.
If it rained last night, had been snow, we'd be socked in here.
It was snow. Was it in Vermont?
Yes, he said it was.
It was snow up there, Mary.
Yes, it was snow in Vermont.
Happy New Year, everybody. 1995. I hope you get everything you want in 1995. We are at Mamaroneck Avenue and Old Mamaroneck Avenue in White Plains. And the people that we just visited were Merrill and Elmer Folsom. And he's 92 and she's 91. And they celebrated their 72nd wedding anniversary. So that is a Happy New Year. And this is Glendora, a chat with Glendora. And there goes a Glendora fan. So as I say again, I hope you get everything you want in 1995. T-shirt off the Lincoln. Looking good. At 15 years old and 200,000 miles, and you can hear him. He sounds good. Just take a look at his other side. have today. This is the field next to our home. This field runs down Greenridge Avenue, from Greenridge Avenue all the way down to Mamaroneck Avenue. And it runs for this whole block. As you can see, it's about 16 lots. And this is the weather that we are having on New Year's Day, 1995. And the time is 12:30 p.m. We just came from church. $1995, New Year's Day, Sunday, at 12:30 p.m. Hi, Shadow.
Oh, you're a good boy. You sit down.
Oh, what a good boy.
Good boy.
Oh, what a handsome boy.
Tail's wagging too. What
Yeah.
a good boy.
Oh, he's a good boy.
What
Shadow,
boy
look at you.
Yeah.
Shadow, you like people, don't you? Huh?
He does. He's looking at squirrels today.
But he
Still
likes people.
going.
Hey, Shadow, look at Glenny. Hi, Shadow.
What a good boy you are.
Yeah, you're a good boy, Shadow. Oh, how old is he, Bill?
He's 2.5.
He's 2.5?
He's 2.5. He'll be 3 in February.
Oh, you're utterly handsome, Shadow.
So he's still growing and maturing.
Yeah. He likes to go for walks, doesn't he?
Oh, yeah. I walk probably 5 miles a day with him.
Do you really?
Oh, yeah, sure. I have to. He needs the exercise also.
He does?
Yeah, and I run him on the weekends.
You do?
Yeah, I do.
You got a place up in the country where you can let him go?
Oh, I run him over in Greenberg at the Mohawk Day Camp.
Oh, yeah?
It's closed, you know, obviously in the wintertime. So I run him over there, and he enjoys it.
Oh, you're handsome, Shadow. What you looking for?
He's squirrels.
Yeah, you're looking for squirrels.
Look at the squirrels today. You're a good boy today, Shadow.
Oh, he's a good boy. And see, he walks up and down the...
Up and down the entire Greenridge Avenue.
Really? Oh, yes. What, you full of kisses? You got kisses, Shadow? Or did you see a squirrel? Yeah. So this is Shadow on New Year's Day, 1994.
1995.
Excuse me, yeah. This is, let me do that over again. This is New Year's Day, 1995, Sunday, and the temperature is 51 degrees. Aren't we lucky?
Very. A little overcast, but pretty nice.
A recorder from Friday night, December the 30th, 1st. No, that would be December 30th, near New Year's. And they came from Nassau County, Channel 25, when A Chat with Glendora was on. Let's press the smart button.
Fucking crap you put on TV, you Irish fucking drunk. Get off the fucking air, man. Nobody wants to see your fucking big dirty ass. You're a pig, I find you offensive, and I wish you'd get the hell off my TV. Bill Shop of Eggs, 9406107. Hi, my name is Chris, and give me a call back at 914-232-1830. Thank you. Bye-bye. Happy New Year. Glendora Franklin. Happy New Year, you too. Bye.
And that's it. And today is New Year's Day, January the 1st, 1995, Sunday. And the time is 4 p.m. And the days are getting longer and longer. Oh, that's nice. The morning of January the 3rd, 1995, Tuesday. I opened the door and discovered this torn up log, plus a copy of Grounds for Eviction to John Porzio, Grounds for Eviction of Walsh and Alpucci. The person who did it remains anonymous. Some of it is on the stairs going up to the Walsh apartment. At 7 a.m., Franklin distributed the log to 13 apartments. To 13 apartments. This would be one of those. Was made is 8:40 a.m. January 3rd, 1995, Tuesday. Now, folks, here to sing this morning's hymn is Franklin Buell.
God of grace and God of glory, on thy people pour thy power. Crown thine ancient church's story, bring her bud to glorious flower. Grant us courage, grant us wisdom, for the living of this hour. For the living of this hour.
Hi there, everybody. How are you today? And here are the first jokes of the year 1995. I just hope that you get everything you want in 1995. What happens when ducks fly upside down? They quack up. And did you hear about the Chinese telephone directory? They've given up publishing a Chinese telephone directory. There are so many wings and so many wongs. Everybody is winging the wrong number. And the IRS agent said to Robert, I'm having a little problem here with your medical deductions. It's very hard for me to justify $50 for the tooth fairy as a medical deduction. We must tell you what happened on Scott Lord from December the 29th, since we last met, to January the 5th, which is today, 1995. We are coming along very well on the United States Supreme Court writing the petition for a writ of certiorari. And this is the argument that has been typed so far. Why this was a bad decision, why it was bad work by Judges Hall, Judges Duberstein, Gattell, Winter, Jacobs, and Cabranes. And the typed part is up to 31 pages. The written part is up to 60 pages. And up to page 60 has to be typed today, and up to page 65 will have to be typed, will have to be written today, and that should finish the argument. And then in the rest of you, then you have all the other stuff about the jurisdiction and all the table of contents, the table of authorities, the laws, what constitutional law, and so forth. As you know, I'm using the Fifth Amendment and the 14th Amendment, and also that my rights as a citizen of the United States were violated under color of state. Okay, and I have to read 5 pages from the Book of Rules of the United States Supreme Court. It was so disappointing. Their term starts the first Monday of October every year, and the first Monday of October of 1994, the Supreme Court announced that they weren't taking any new cases. That is a real sin. What are we paying and having all the expense of the United States Supreme Court if they can't hear our cases? When the United States Court of Appeals does such a bad job, as in the case of Judges Winter, Jacobs, and Cabranes, when the United States District Court does such a bad job as in the case of Judge Cattell, and when the United States Bankruptcy Court does such a bad job as in the case of Judges Hall and Duberstein. So here's the front part of the writ, the petition for writ of certiorari. Now I call up the Supreme Court and I ask them questions, and they didn't do so well before New Year's or before Christmas or something. They were pretty good the first time I called them, or second time, but they didn't do so well. They broke down. Everybody breaks down at Christmas and New Year's Day, almost everybody. All they're interested in is loafing. They're not interested in doing the job that they're getting paid for, and that's out dishonest. But yesterday I called them. They were pretty good. And so now I just limit it to one question a day, and that cost me $1. It costs $1 to call down to Washington, D.C. And so yesterday they were pretty good, and the day before they were pretty good. So eventually I hope to get all my questions answered. And this is due on Groundhog Day, February the 2nd, but I want to get it in early, folks. In case there's any mistakes, I'll have a chance to correct them. Because I think you only get one shot at this. I spent on Scott Lord the last 7 days was 17.5 hours, and the total cost was $0. Big job like that done, folks, by comparting it, doing a small part of it every day. And if you do that every day, you'll get it done. The trouble is you have to answer some lying, thieving, crooked lawyer's paper every day practically. One day last week I had 13 papers to do. Today I only have 5 or 6. It used to be if you had one every other day you thought it was horrible. And then one a day was horrible. And now when you have like 13 in the same day, or 5 or 6 a day, and it's at least 3, 4, or 5 a day. It's terrible, terrible, terrible. Don't ever look for justice in the courts. Don't ever try to solve your dispute by going to court. The courts are broken down. The courts should be closed down. They should put up a sign, out of order, closed for repairs, and stop the sham. The policeman said to Diane, "Your license says that you should be wearing glasses." And she said, "But I have contacts." And the policeman says, "I don't care who you know. You're going to get a ticket anyhow." And the warden said to Robert, "Robert, you must be lonesome in here. You never have any friends or relatives come and visit you." And Robert says, "Oh, no, warden. They're all in here with me." And the diner at the restaurant said to the waitress, "What do you have for dessert? What flavor ice cream do you have?" And the waitress said, "Vanilla, chocolate, and strawberry." And the diner says, "You sound hoarse. Do you have laryngitis?" And she says, "No, just vanilla, chocolate, and strawberry." Here's Ginny Cat. Ginny Cat, you're a very intelligent little kitty. Oh, yes, you're very intelligent, Ginny. You're very intelligent. Want to eat your peas? So now we're going to tell you what happened on Glendora versus Cablevision. Charles Dolan, John Tata, William Quinn, William Bell, Mark Lusgarten, Francis Randolph, Joseph Asnara, Urban Polinsky, Charles Forma, James Dolan, Cablevision Systems Corporation. Okay, and we'll pick up on what happened last Thursday. It took 2.5 hours to videotape the Cablevision stories of last week and to edit them. That's wrong. It took 2.5 hours to videotape and edit. No, videotape. It took 2.5 hours to videotape everything. The footage was 2 hours and 10 minutes, so that's pretty fast videotaping. That's what happens when you start out live in television in 1954. You learn to do everything right the first time. And then we edited at TCI from 50 to 7 p.m. Now this is Ginny in her gray fur coat When you grow old, Ginny, what color are you going to turn? What color will your hair turn when you grow old, Ginny? Because you're gray now. She's 3 years old now. It says here what we need is for people to stop breaking the law. She's eating her peas. Lawyers to stop lying, greedy and grubby, and judges to stop being corrupt. What we need is people to live lawfully, live by the Golden Rule and the 10 Commandments. And there goes Ginny. Bye, Ginny. I watered the plants at 222 Mamaroneck Avenue that were out in the hall. And the Lincoln was run down because of the flashers were on so long when we came out of editing at TCI, White Plains. So I went across the street to the fire. I took my cables, my boosters. The Lincoln came with boosters. That ought to tell you something. Very fancy cables. And 15 years ago. And I was carrying my cables and I went across the street and I opened the little door. And there were all the fire trucks, and amid all the fire trucks I saw a fireman, and I said, "Fireman, will you please boost my Lincoln?" And so they did. They used a little scout truck, a fire scout truck, and they went across the street and boosted it and started up right away. Thank you, fireman. Thank you, White Plains firemen. And these are Ginny's peas. Cablevision law breaking on television is up to chapter 97. You would think they'd do something about it. The Waltz law breaking went over 100 chapters. You would think they would do something about it. Every morning it takes about 20 minutes to do the to-do list, to write down all of the things that have to be done today, the details, the telephoning, the errands, the legal papers, the operations. A stockbroker talked to me at great length about buys on Texaco and Gannett. I won't buy Cablevision stock anymore because they don't pay any dividends. All of the money goes to the people whose name you see here on the screen. I talked to Bill Brasnan, who was the man who introduced me to Charles Dolan way back in 1987. Bill has 65,000 subscribers in Poland. He has 65,000 subscribers in Chile, and he has 200,000 cable TV subscribers in the United States of America. Officer Fisher took Roberta Walsh triple injury report on Glendora. BTJ cannot buy an ad this week. The CBS annual meeting is at the same place, the Museum of Modern Art on 53rd Street, I believe, between 6th and 5th on May the 10th, 1995. I'm going to read you, under the miscellaneous, the third quarter report of the CBS, Columbia Broadcasting System. Eleanor and Merrill Folsom, who are 92 years old and 91 years old, were ripped off by a plumber for $800. I think that's terrible to rip off old people. Like, they should be liars. $1.5 billion asset company, Cablevision Systems Corporation. I think that's terrible to rip off old people. Like, they should be liars. $1.5 billion asset company, Cablevision Systems Corporation, still refuses to pay Glendora her costs of $797 on her lawsuit against Cablevision, where Glendora won and Cablevision lost, and the Park Avenue lawyers lost to a pro se. David Deitch is loafing. The recorder was on all through the week, all around Christmas and all around New Year's. Colabella was loafing. The whole courthouse was loafing. All of the judges were loafing between Christmas and New Year's. We pay for that great, great big courthouse tower so that it can be unused for a whole week. And you go in there with the case and you wait a year and you wait a year and a half so that these people can loaf for a whole week and a whole lot more that doesn't go on the record. Patricia White, a great deal. She is working on a case against Cablevision. And it's sort of a freedom of speech case, because freedom of speech not only applies, for instance, Cablevision censoring Glendora and taking the program off the TV, That's one freedom of speech violation, but it's also a violation against you because you want to watch a chat with Glendora. You want the information, and that's the gravamen of her case, is that Cablevision violated the viewer's freedom of speech because the viewer wanted to see a chat with Glendora, and Cablevision denied the viewer that right. So it's sort of an interesting case. Robert Perry is working on his reply brief against Cablevision. He's on the side of the town of East Hampton, who wants a different cable supplier, a different cable operator, which they should have. And he's working on the reply brief. That's in the United States, the United States Court of Appeals at Foley Square. And he heard of another Cablevision freedom of speech case that was brought against Cablevision in Connecticut. There's a very famous one that was brought against Cablevision of Connecticut. That's AMSAT versus Cablevision of Connecticut. Well, this is a new one. They did the same thing to the person in Connecticut that they did to me. So Cablevision is being sued in Connecticut on freedom of speech. So my case with Judge Silverman lays the groundwork for that. No cable operator can exercise editorial control over public usage channel. Vision Friday night, December 30th, which would be New Year's, December 30th, which would be the night before New Year's Eve. And I have somebody I'd like to say hello to, and that's Vincent Cloutier, who first watched a chat with Glendora in a bar. And I asked him, did a lot of other people watch it? And he says, yeah, quite a few of the guys were watching it. And he said, they like your hat. That's hello to Vincent Cloutier, and we shoot Happy New Year, and that you get everything you want in 1995. And he lives in Rockville Center. That's the town out of which Scott Lord ripped off so many people. And just before I met him, and Scott Lord lived in Rockville Center for some time. Still impressed by that little cable system, 5,000 subscribers, United Video, up in Cross River, Golden's Bridge, South Salem, North Salem, Purdy's, all those little northern woods, Westchester towns. The response I get from United Video, Cross River, is fantastic. Bob McGinnis from Golden's Bridge, he called up, he says, Glendora, he says, you're terrific on TV. And Glendora said, where am I on TV tonight? And he said, in Lewisboro. And I said that I was glad that he told me, because I have no way of knowing it, because the cable company, of course, only covers its own cabled area. It doesn't come to White Plains. Center for some time. Still impressed by that little cable system, 5,000 subscribers, United Video up in Cross River, Golden's Bridge, South Salem, North Salem, Purdy's, all those little northern woods, Westchester towns. The response I get from United Video Cross River is fantastic. Bob McInnes from Golden's Bridge, he called up and he says, Glendora, he says, you're terrific on TV. And Glendora said, where am I on TV tonight? And he said, in Lewisboro. And I said that I was glad that he told me, because I have no way of knowing it, because the cable company, of course, only covers its own cabled area. It doesn't come to White Plains. And it was on from 7 p.m. to 9 p.m. every Friday night. And he wanted a Glendora Happy Book, and this is what he said, quote, you do a great service. You keep people on their toes. Judicial is the worst branch of government, and I know because I've been a witness and a juror, and they fix things. And how do they ever? So it was a good way to end the year. It was New Year's Eve, I think, that he called me. Now, let's see, how does Cablevision end up for the week? Here is a paper, a page copied from the Securities Exchange Commission. And I sent this copy to Cablevision to remind them of precedential significance of the Department of Justice, of the federal grand jury, of the general counsel, of the rulemaking and interpretation, and legislative matters handled by the general counsel of the Securities Exchange Commission, and handles all cases in the appellate courts, and the filing of briefs. And sometimes the Securities Exchange Commission enters as a friend of the court, an amicus curiae, and the General Counsel deals with proposed legislation, and the Office of the Chief Accountant, folks. His objective is to improve the accounting and auditing standards and to maintain high standards of professional conduct by the independent accountants. Regulation SX. The office administers statutes and files that require that accountants examining financial statements filed with the Securities Exchange Commission be independent of their clients. Well, I doubt that they are. At every annual meeting, you have to vote who the accountant's going to be. The Commission's rules of practice, which specify reasons an accountant may be denied the privilege of practicing before the Commission. And these reasons include lack of character or integrity, lack of qualifications to represent others, unethical or unprofessional conduct, or the willful violation of, or the willful aiding and abetting of violation of any of the federal securities laws, rules, or regulations. So I have questions about that as far as Cablevision Systems Corporation goes. The chief accountant supervises the procedures followed in accounting investigations conducted by the commission staff. So I sent that to Cablevision. This is the log that I send to Cablevision every week. I'm coming along fine on the New York statutes, folks. I'm up to the 13th book. There's only 6 library shelves full of New York statutes. I'm up to the 13th book, which is part of the CPLR, which is Volume 4D of the CPLR. And it's Article 30, which is pleadings and remedies. Ooh, here's another thing from the SEC. And now I'm reading the complaint forms. To show lawyers how to file complaints. A lawyer doesn't have to know beans, you know. All he has to do is go to the books, and the forms are all made out, and he just has to fill in the blanks. And let's see what the week's tally is on Cablevision. How many hours and how much money. An hour spent on Cablevision. The week that closed on around about New Year's Day, and $1.66 was spent on Cablevision. These are some little post-its from Diane Bennett, who does such a good job at Hicksville, although she was away, and showing how she asked a technician to dub my show over again so that both the voice and the music would be on channel 2. They want channel 1 blank. So, and the show, you remember the night of the storm, of the nor'easter, December the 23rd, 1994, Friday. The cable went out and Con Edison went out. Well, just to show you how great Hicksville is, they're going to re-cablecast program 1631. Because I know nobody saw it much because the telephone didn't ring at all. And always when the program is on, the telephone rings. It rang 5 times Friday night, December the 30th. That would be the night before New Year's Eve. On the New York statute, we found forms how to sue a foreign corporation, such as Cablevision, which is incorporated in the state of Delaware, how to sue the public officers. We've started the income tax on New Year's Day, and that's a big job. So there again, you have to compart that into little small jobs. So the first thing we do is figure up the mileage, how much mileage was personal, how much mileage was business. Turned out to be 77% business, and then you know all the car expenses, and 77% of that is entered on your income tax as a business expense. These are some more quotes from the Securities Exchange Commission about Cablevision, coordinating the legislative efforts of the Commission and communicating between the Commission and Congress. That's what the Office of Legislative Affairs does. The Office of the Inspector General audits and investigates. He keeps track of the economy, the rulings that the Securities Exchange Commission might make that would have a great effect on the economy. The SEC and federal, state, and local government agencies and non-government agencies, including the identification and prosecution of individuals involved in fraud and abuse. So we have to watch that. Here is from the Cablevision third quarter report. I finished that, and it looks to me like the bottom line for the it's unaudited, the assets. It looks like the assets are $2.2 billion as of September 30th. And Rainbow Programming has, pursuant to its new ventures agreement with National Broadcasting System, that must be because of the Rainbow Lounge on the 30 Rockefeller Plaza, right? NBC offered NBC the opportunity to participate in 1/2 of Rainbow Programming's investments and holdings. NBC has until November 15, 1994 to decide whether it will participate. In the event that NBC elects not to participate in the transaction, it may require Rainbow Programming until the later of January the 25th, 1995, or 30 days following the closing of the Madison Square Garden transaction, or the termination of the merger agreement to purchase its interest in Sports Channel New York Associates, Sports Channel New York abbreviated, and Rainbow News 12, the NBC put, for an aggregate purchase price of approximately $92,000. No, $92 million, because the dollars are in thousands, unaudited, at November 15, 1994. We have other Cablevision entities, MFR, and Monmouth, and Riverview. We have Cablevision Cleveland, we have Cablevision Boston. And it's so convoluted and it's so mixed up, folks, that you really can't possibly follow what's going on in the Cablevision third quarter report. Now, Cablevision, this is a Note 6 pro forma. I wonder if he's related to Charles Forman, one of the Cablevision attorneys at One Media Crossways in Woodbury. And they add up all these figures that I showed you, and what's the bottom line? They don't give you any dividends. Cablevision never gives dividends. The money goes to the people that you see, whose name is on the screen. Oh, and Cablevision, the company recorded a one-time charge of $4.3 million in March 31st, 1994 to fire people. It cost them $4.3 million to fire people for severance and related costs, terminated employees. And they're only going to get a 7% increase starting this week. Or actually, it will be on your bill in February. All the cable companies can soak you for another 7%. Thanks, Congress. Thanks a whole lot, Congress. And here is a lie. This is the third quarter report of Cable Systems Corporation. Legal proceedings. The company is party to various lawsuits. I have 3 against them, some involving substantial amounts. Management does not believe that such lawsuits will have a material adverse impact on the financial position of the company. Believe that propaganda, if you will. The company filed a current report on Form 8K with the Commission, the Securities Exchange Commission, on September 21st, 1994. Now, under the Cablevision New York City purchase agreement, the restricted group has guaranteed certain payments to Charles F. Dolan, the chairman and chief executive officer of the company, consisting of an annual payment of $5.6 million, a $40 million minimum payment, and a preferred payment not to exceed $150 million based upon an appraised value of Cablevision New York City. I say, how about guaranteeing payments to shareholders, which we call a dividend? So that's what, here's another Charles Dolan payment. And the required upgrades under the New York Upgrade Agreement with the New York State Commission on Cable TV to find its anticipated investments, including the $5.6 million annual payment to Charles Dolan. Charles Dolan lives in Oyster Bay, as you know, on Cobneck Road. And this has something to do with the proposed Cablevision of Boston transactions and the Rainbow programming, $110 million investment in Madison Square Garden. And then we have AR Cable and V Cable and the senior secured indebtedness incurred by those entities. We have here again the Commission on Judicial Conduct. I include that in a letter again. Let's go on with Cablevision here. Here's some jokes. The suit against Michael Gallman, who's the producer of Live with Regis, goes way back to 1980 of audio tape conversations, and we have to go through those and listen and find the statements of Michael Gallman whereby he made a contract with me and breached it. And so on one of those audio tapes was a conversation that Franklin Glendora and Charles Dolan had way back, 1990, 1991. And Glendora was telling Charles Dolan that Cablevision wouldn't pay the $255 that Glendora won as a judgment against Cablevision because Cablevision ruined one of Glendora's broadcast TV commercials. I had hired Cablevision to edit a commercial for me, and in the process Cablevision ruined one of my WABC TV 1-inch, well, 3/4 inch master commercials. And I sued them for $200, and it came out to $255 with the charges, and they wouldn't pay it. And so we were complaining to Charles Dolan that they wouldn't pay it. And Charles Dolan kept saying, I don't have anything to do with that, Glendora. I don't have anything to do with that, Glendora. And Franklin finally added that every day they were disappointed in the way Cablevision was run. And this goes way back, long before they broke the state law and the federal law and all the other laws I've told you about in 1994, 3. This was 2 years before that. It's a badly run company, a very badly run company. As you can see, they were up to about 100 chapters of their law breaking. This is all of the third quarter report. And I think I read you the important parts of it. It took me from the 1st of December through to the 31st of December, the whole month of December, by reading one page a day. That's all you can get time for, to get it read. And now for some jokes. Why was the little shoe crying? Why was the little shoe crying? His mother was a sneak and his daddy was a loafer. And the woman came along in a taxi cab, and the taxi cab pulled up to the curb, and the woman says, "How much do I owe you, driver?" And the driver says, "Nothing, ma'am, you did all the driving." And did you hear about the woman who calls her son Halley's Comet? She's angry with her son, and she calls him Halley's Comet because he doesn't come around to see her except once in every 74 years. Now this is the log on Glendora versus Gannett Broder, McCorkindale and Curley and Sherlock and Watson and Paulson. And this is the log that will be sent out sometime pretty soon. It's up to 32 pages. And the time on Gannett Broder this week was 2 hours. The cost was $0. And what are we waiting for? We're waiting to finish the petition for writ of certiorari to the United States Supreme Court on the Scott Lord, Judge Duberstein, Judge Hall case, Judge Cattell, Judge Branis, Judge Capranis, Judge Winter, and Judge Jacobs. We're waiting to finish that petition, and then we'll start our petition to the United States Supreme Court for all of the law-breaking that went on with Gannett and the failure of the court, the Judge Broderick Court in the United States District Court in White Plains, to deal with Gannett breaking the law, and the failure of the United States Court of Appeals, Judges Laval, Pratt, and Cabranes' failure to deal with Gannett breaking the antitrust law and the monopoly law. So that's going to the United States Supreme Court. That's about all that we're waiting for there, I think, on Gannett Broder. Seems there was something else to tell you. There were 3 lawsuits against Gannett. The first one was against Gannett for breach of contract. They said they would write a story. I gave something like 30 hours to them. And then Mitch Broder said in his childish way, "I just may not write this story." And so that was breach of contract. The courts were all wrong in their ruling of that because they're all afraid of Gannett. It's too bad when you sell your soul. It's too bad as a judge you can't stand up for what is just. And then the second lawsuit was against Gannett for libel. They committed libel when they wrote about the decision, the bad decision of Judge Johnston in Harrison. They told a lie, and they never printed both sides. And it was defamatory what they wrote. But Judge Burroughs and Charles Devlin are too afraid to rule against Gannett again in the Westchester Supreme Court. And I took that to the appellate division, and the appellate division is too afraid to rule against Gannett. And so the third lawsuit against Gannett was for obvious reasons. In Westchester, Gannett is a monopoly and an antitrust, and it injures people. And so I took my action in the United States District Court. But Judge Broderick, who was not of sound body and should not be on the bench, as the Judicial Conduct Code says, he made a terrible decision on that, as bad as his Cablevision decision. And so I appealed that in the United States United States Court of Appeals. And the 4 judges I told you, Laval, Pratt, and Cabranes, stuck with Gannett. Everybody's afraid of Gannett because they're a monopoly. Everybody sells their soul. In these courts, they just sell their soul. The soul's not worth 2 cents. I wonder how much they sold it for. Well, we know how much they sold it for. We know. So that's all that's going on, Glendora versus Gannett Broder, on this week of December 30, what was it? December the 29th. 1994 to today, January the 5th, 1995. Dividend check from Gannett. That Warren Buffett has bought 4.9% of Gannett. You hear about the man who called up the newspaper. And I'm alive. And the editor felt really bad. He felt very badly. And he was trying to think how he could make it up to the man. He says, I'm so sorry that we put you in the obituary column. He says, I know. He says, tomorrow we'll print your name in the birth column. Then you can get a whole new start. The teacher said to the little boy, how do you spell rose? The little boy says, B-R-O-S-E. The teacher says, there's no B in rose. The little boy says, there was in the one I smelled. And the honeymoon couple came back, and they settled down to married life. And he said, dear, do you want to be the president or the vice president? And she said, you can be both, dear. I'll just be the treasurer. Now first, you have the landlord breaks the law. That's the first thing. The landlord charges you $1,050 a month for an apartment where the regulated rent is something like $400 a month, or maybe $600 a month, okay? So that's the first law breaking that you have. And then you go to the New York State Division of Housing and Community Renewal. And the law says clearly, the Emergency Tenant Protection Act says clearly that if the landlord does that and doesn't show proof that he did it unintentionally, then the Division of Housing and Community Renewal shall give you triple damages. First of all, the landlord has to refund the overcharge, but then he has to pay triple the overcharge. That's what the law says. The law says that clearly. So the next lawbreaker is the New York State Division of Housing and Community Renewal. And so then you've been ripped off, so you go to court and you show them that they have broken the law and that you should have triple damages. And the next person to break the law is the judge. In this case, it's Judge Matthew Coppola. I'm very sorry that he was reelected. It's another 14 years of paying Judge Matthew Coppola $113 a year, not to uphold the Constitution, not to uphold the laws of the state of New York. So he's the next one who breaks the law. And then the Division of Housing, Judge Coppola tells the Division of Housing and Community Renewal in the Bronx, after he rules in their favor, he tells them to submit an order. And they forget all about it. They're typically like that. You know, they'd forget their head if it wasn't attached to them. That's how the DHCR operates. And so Glendora tells the judge that she wants the whole thing vacated because they never submitted the order to be signed. It's a sloppy way for a judge to do anything anyhow. He should sign the order. And so we have the next law breaking, that's Judge Coppola again. After they've broken the law of not submitting the order in 60 days, as the law says, he lets them get by with it. Not only lets them get by with it, he colludes with them. And so that's the next law breaking. In the meantime, the law says, the Emergency Tenant Protection Act says that if a landlord harasses a tenant to move, and in this case, my landlord did that 13 times, and it's all on audio tape, that should be charged, I think it's $1,000 for the first offense and $1,500 for every one after that. So that amounted to something $17,000 that this landlord had broken the law. And so you bring that down to the William Street DHCR, Division of Housing and Community Renewal, New York State, and they break the law. They don't enforce the law. So you have all this crookedness and all of this corruption and all of this law breaking. Landlord to the Division of Housing and Community Renewal, to the Supreme Court of Westchester County, down to the New York State Division of Housing and Community Renewal in Manhattan. And you add that all up over a period of 2 years, it makes you very, very, very angry. So your next step is go to look for justice in the Supreme Court, State of New York, Appellate Division, the Second Department. And that's where it stands now. And then you wait there for an oral argument after you submit all your briefs, your appellant's brief, and the respondent's brief comes in, which was terrible, and there were 2 of them, one from the crazy Attorney General's office of the state of New York, and you submit your briefs, and I answered those briefs, a reply brief, and then after that you sit and wait a year and a half for the appellate division to get on the bench and listen to your oral argument, and then you wait a month for that decision. So I figure the oral argument will be along Christmas time, 1995. Left her little 7-year-old daughter with 2 older ladies, for the older ladies to look out for the daughter while the mother did something, very briefly. And as the 2 older ladies and the little 7-year-old girl sat together in the room, one of the older ladies said to the other one, "She's not very P-R-E-T-T-Y, is she?" And the little girl says, "No, but very S-M-A-R-T. And why do geese fly south in the wintertime? It's just too far to walk." And the young man took out on a date the young woman, and during the conversation of the evening, the young man said, "What kind of sports do you like best?" And the young woman said, "The kind who spend their money and go home early." Versus Lydia Gallicano, the time spent on Lydia last week was only an hour, and the costs were 0. But this week it's a different story. This, as you know, she brought an action, which was a crazy thing to do, about owing her $1,800 rent. And I don't know where she got the figure $1,800 from. And it ended up that she had to pay me $1,580, that it was all adjudicated. And I made this motion to the court to dismiss her small claims action on the basis of the Uniform Justice Court Act, Article 18, Section 1810, that she was using small claims as an instrument of harassment, and that she should be denied the use of small claims because this matter that she brought before the Small Claims Court back in October, November of 1994 had already been adjudicated. And it had been adjudicated almost everywhere, in the Judge Holden Court, White Plains City Court, and in the appellate term of the 9th and 10th Judicial Districts. So it was really fully adjudicated, and she paid me the $1,580. So it really was a crazy thing to do. So yesterday, Thursday, January the 4th, was small claims date at 4:30 p.m. We went to the courtroom. Judge Joanne Freer was presiding. The courtroom was packed. About 15 people were standing. They had no place to sit. But Joanne Freer came to the bench, and she dispatched her business very, very well. small claims date at 4:30 p.m. We went to the courtroom. Judge Joanne Freer was presiding. The courtroom was packed. About 15 people were standing. They had no place to sit. But Joanne Freer came to the bench, and she dispatched her business very, very well. One case after another, she heard what the sides had to say. Those cases that where either the plaintiff or the defendant didn't show, she put them down for second call. And then other cases she gave trial dates to. And she really went through the calendar very thoroughly, about 4 times. And she never called our case. And then finally, around about 5:20, that would be 50 minutes later, she called Lydia Gallicano versus Glendora. And so I will play for you what happened in the court yesterday. We went up. Franklin took shorthand notes. There they are, 3 pages of those. And I took handwritten notes, and I had 3 pages also. And this is what happened. I think I'll turn off the light for this, okay?
Um, one for the recovery of money only, up to a sum certain, which is now $3,000. The nature of your counterclaim is really intentional infliction of emotional distress, and also some of the arguments made under 1810 itself, which is harassment and so on. This is really the basis. 1810 is the basis for keeping cases out of our courts, not keeping them going in our courts. So that the nature of your counterclaims are not appropriate for small claims. They don't seek a money judgment or are not based in any sum of money as a basis for relief. They rise to the level of equitable claims, and that is really not the jurisdiction of small claims. While we can grant decisions based on equitable remedies and equitable theories, the lawsuits for which you are counterclaiming are really retaliatory in nature. And I think that the relief of dismissing Ms. Alejandro's case is enough. The case is out of the court. It's being heard. I wasn't damaged? No, or at least you weren't damaged in a way that is provable by money damages. I think that's the bottom line. When you got the relief of restitution from the court, did I read it correctly? That you also granted restitution by the appellate term upon the reversal of the judgment. If I read well, I got paid. You got that, got your money back. $1,580. No, it's not all my money, but I got $1,580. Right. Then basically you recovered whatever damage you suffered as a result of the claim itself. All right, and that was the original claim in the landlord-tenant part of our court. So that there's no theory here of recovery of a sum certain. Your equitable arguments, but again, what did you say? Of a sum certain. No fear? No theory? No theory for the recovery of a sum certain, which is what small claims actions are. They are a suit for money damages. That's the only kind of relief that we can give on a sum certain, a provable sum of money, up to now $3,000. And the nature of the counterclaim that you have really don't present claims for money damages. They present claims of a higher and different nature, more appropriate for a different court, not small claims, not small claims action. They are also really responsive, I think, to the lawsuit that was brought against you, and I'm granting you the relief of dismissing it. And I'm dismissing it not only under 1810, but also under 1808, which is outrage, collateral, estoppel provision. Okay? All right, I will write this up in a decision. You got to give me some time. This is the first week we're just organizing ourselves here. But that will be my decision. I'm looking for what she sent us. I don't even know if it's still in the file. I think it was just here it is. Yes, we just got it in the mail today. December 29, we can make you a copy. She didn't send it to you? No. Okay, well, we just got it. The date is the 29th and it came in the mail today. If we can make a copy when we get a chance, thanks for your Glendora. I did review that. Consider it part of my decision, but that's it. So that your motion is granted and the case is dismissed. Okay? And to the extent that it can be dismissed with prejudice, it is dismissed with prejudice. Oh, it is? Well, this can be, yes, because under 1808, it's res judicata. So you can't have the thing again. 1808 res judicata. That's awesome. It's like Arthur 211. It's really a queer thing to do. I know. Well, she thanked me if she wants to touch on it. Okay? Thank you, Judge Freya. Very good. Okay.
That's it. Hooray! That's a great victory for tenant. That's a victory for tenants. And it's a defeat for landlords, because as you know, the landlords have $1 million lobby up there in Albany, and they ruin our laws and our tenant protection. And so even with that, here is a victory of a tenant over a landlord. It's very significant. When a tenant wins, it's very significant. So we have to tell that to the New York State Tenants and Neighborhood Association, which is, if you are a tenant, I think you should belong. The New York State Tenants and Neighborhood Association. So I went and said hello to Trudy, who was the clerk sitting next to Judge Freya. And I talked to Eric today. And I whispered to her, how is your dog? She has a dog, she lives in Pelham. She takes the dog for a walk every day. And then I was waiting for the copy, and the copy of the letter came. Boy, you know something, without any light, you can almost read that, can't you? So I'm going to read you this letter. I better turn on the light because sometimes the low level of light makes a problem when you're editing and the tape jumps. So I better turn on the light. December 29, 1994, this was received by the court on January the 3rd, 1995, which was the day before the small claims. You understand that Lydia Gallicano did not show up, and nobody else showed up to represent her. Our Honorable Joanne Freya, City Court of White Plains, South Lexington Avenue, White Plains, New York, 10601, Re Gallicano versus Glendora. Dear Judge Freya, I was asked to write a letter to you to explain why I should be entitled to sue for rent that was not paid by a former tenant. I was informed by your court clerks that you would be deciding Glendora's motion and my right to sue in small claims court on the 4th of January. For the following reasons, I think that I should be given the opportunity to recoup my wrongfully withheld rent. Well, she's wrong about that. She's wrongfully wrong about that. 1. I sued Glendora for wrongfully withholding $1,250 of rent due to me for the rental of the first floor of my property located at 40 Longview Avenue, White Plains. Glendora withheld the rent money because she had perceived violations which did not exist. That is not so. The violations existed and many more. Glendora claimed that I did not have a certificate of occupancy, which I did in fact have. She did not. She did not have a certificate of occupancy until I got after the building department, and then the building department gave her a certificate of occupancy without any inspection. In addition, Glendora wrongfully deducted amounts from the rent because I trimmed the hedges on my property which she claimed she had nurtured. She ruined the looks of the place, okay? And I had a right to have that place as I had rented it, and I had a right to enjoy the shrubbery that she brutalized. We were awarded $1,550 by Judge Holden in the White Plains City Court for the rent and attorney's fees. The appellate term reversed the judgment because I had not given Glendora a 3-day rent demand notice prior to instituting the summary proceeding. The appellate term did not rule on any facts of the case. If she wanted the appellate term to rule on the facts of the case, why didn't they get their brief in time? They never got their brief in on time. They got it in late, and the appellate term did the proper thing, turned it around unread. And therefore, because they didn't get their brief in on time, and because they didn't get any brief in at all, so to speak, they could not argue with the oral argument. So how could the appellate term hear any facts? Glendora vacated the premises over 2 years ago, and I have not been paid the proper rent pursuant to her lease. She broke the lease. I believe that I should be afforded the opportunity to retrieve this money. If she believed that, why did she pay me the $1,580 back in November of 1994? I cannot believe that the court system is designed to allow someone to avoid paying their rent because I failed to send them a demand notice. Why not? It's the law. It's the Real Property Actions and Proceedings law. The appellate term decided solely on the notice issue. I don't know what that means. And did not decide or rule on any facts of the case. And we've been over that before. They didn't get in any brief on time. Glendora is apparently attempting to countersue me in the small claims court by filing a motion. I thought that no motions or other legal proceedings were permitted in the small claims court. I think she thought wrong, to allow people to redress wrongs without benefit of legal counsel. She could have answered the motion. She never opposed the motion. And that's what she should have done. She should have opposed the motion. So Judge Freya had no opposition to the motion. If I am required to retain legal counsel in the small claims court, well, she's not required to retain legal counsel. She can do it on her own, as I did it on my own. I don't retain legal counsel. If I am required to retain legal counsel, Lydia Gallicano writes in the small claims court, I will have to incur significant expense, which I always understood not to be required in small claims action. Wrong again. She's wrong again. Not about the expense, but about the fact that she needed legal counsel. And her legal counsel always has been her son-in-law, where he didn't show up on this one. Thank you. His name is John Ornberger, which you remember well. Thank you for attention to these matters, and I look forward to speaking with you on the 4th of January. Okay, how come she didn't show up then? She never showed up. How come she never served a copy of this on me before January 4th, 4:30 p.m., the date of trial? Have a happy and healthy New Year. Sincerely, Lydia Gallicano. So, it was a victory for tenants and a defeat for landlords. And we need more and more of that. These greedy, grubby landlords like greedy, grubby lawyers. Now, there will be what happened in the Judge Freer Court will have to be written up. There'll have to be a transcript of it. It'll be put in the file. And again, I will take the file down to the cellar bin and put it away. And again, I would think that the matter with Lydia Gallicano is over. You notice that Judge Freer not only dismissed the case, but she dismissed it with prejudice. And what that means, folks, is that if it is dismissed with prejudice, then she never can bring it back again. She never should have brought it back this time, because it was res judicata and it was collateral estoppel. Pursuant to sections 1808 and 1810 of the Article 18 of the New York State Uniform Justice Court Act. The small claims is Article 18. Now, if you get into small claims, just simply go to the library, almost any public library, certainly White Plains, certainly Greenberg, certainly Mount Vernon, certainly Yonkers, and order the Pace Law Library. And you go there and you look up the Uniform Justice Court Act, and you look up Article 18, and it's the Small Claims Court Act. Glendora versus Cano on this week from December 29th, 1994 to January 5th, 1995, today, Thursday. And I certainly hope that is the end of it. You notice that she never brings out the fact that she lied, stole, and cheated from us by charging us, by not paying the Con Edison bill, part of it, and when we had to pay all of the Con Edison bill, when we were paying for the electricity to run the furnace and to run the water heater for the apartment upstairs and for the heat in the common area in the hall. So she never mentions that, and that she was punished by Con Edison, and that Con Edison turned all of the charges over to her as of that date that I complained, September 1992, and she had to pay everything, even my stove gas, after that. That's how Con Edison caught her and punished her, but she doesn't mention that, of course. On Glendora versus the Fund for Ancient Courts, Elizabeth Hubbard, Michelle Mayapath, and Alan Beck, what has happened on the week from December 29th, 1994 to January the 5th, 1995, nothing. Ever since the appellate division denied my motion to stay all actions in the spite and malice Judge Colabella court, nothing has happened. That would be Judge Colabella and his accomplices, T.J. Mallon and Raymond Powell. So nothing has happened then, so the ball is in that court, and the next step is for Colabella to set a date to go to the trial assignment part, room 800, and to set a date for the hearing for the crooked charges of Edmund S. Purvis of Larchmont on his demand for $4,500 lawyer's fee, which isn't worth $4.50, And that's where it stands, and nothing has happened on that last week. And the time on the ancient course was about an hour, and that amounted to just keeping up the log every day. And the jokes are, Marilyn says, I expect my husband to be exactly what he is today 30 years from now. And her friend says, that's unreasonable. Marilyn says, yes, that's exactly what he is today. And one poor husband came home from work, and he was all tired out. And his wife says, what, did you have a hard day at work, dear? And he said, I'll say, they gave us aptitude tests, and I flunked mine. And his wife says, that's terrible. And the husband says, yeah, it's a good thing I own the company. And a man came out of a pet shop, and he had a cute little Cocker Spaniel in his arms, and he encountered a friend of his, and he said to his friend, what do you think of this Cocker Spaniel I got for my wife? And his friend thought a while, and he says, that's not a bad trade. Folks, this log was sent out and then it was mailed on Tuesday. And that terrible, terrible increase in postage up to, what is it? What is it, up to 32 cents now? It's awful. It's particularly bad for seniors who are on a fixed income. Their income doesn't go up anything. And Con Edison gets a 7% increase. And cable TV gets a 7% increase, and the post office gets a 4-cent increase on every ounce. The number of tortious acts at the time this log finally closed, here are the 26 people to whom this log goes every week. If they would just stop breaking the law, and if they would just leave Glendora alone, there wouldn't be any log that goes out. But they just can't resist breaking the laws. And it's 4 laws that they break: insulting and abusive language, intentional infliction of emotional distress, the White Plains Noise Ordinance, and the harassment criminal law, harassment, a steady campaign. Let me read it to you exactly. Part 5, Section 1542, harassment. 5. A person is guilty of the offense of harassment when, with intent to harass, annoy, or alarm another person, he engages in a course of conduct or repeatedly commits acts which alarm or seriously annoy another person and which serve no legitimate purpose. That's what that section of the harassment law is. So when this log closed, there were 1,612 tortious acts committed by Daniel, Roberta, and James Walsh, Nella and Theo Alpucci, and Kevin and Andrew Larkin. Andrew Larkin is a Harrison police officer. The number of pages is 2,282, a very, very bad record of law breaking by these defendants. Also the law breaking of their lawyers and the law breaking of the court. So let me read you what did happen. At 3 p.m. I did wall for the whole week, and I can't find the log for the week of December the 12th. And I closed the log, and I worked 14 and a half hours on Walsh this week. The number of dollars spent was $10.21. The James Walsh at 5:30 p.m. on New Year's Eve violated 3 laws for 21 minutes. That would be harassment, emotional disturbance, and the White Plains Noise Ordinance. Whistling, roller skating, under my south bedroom window. I put up the curtains and I blocked his view into our apartment, and I put up the sound barrier, which is a foam rubber pillow, a very large one and very thick, and it absorbs the sound. He finally gave up his breaking of the 3 laws just to harass at 5:51 p.m. and he went upstairs with his roller skates on, making a clunking noise and much more noise than he needed to. After that, New Year's Eve, everything was quiet, peaceful, and law-abiding from 5:51 p.m. to 5 a.m. And 1995 came upon us, January the 1st, Sunday. The laundry washers and dryers worked beautifully. Mary Ann did a fine job making the halls look clean and smell clean. Glendora went out especially to wish her a Happy New Year, and also her son Michael. And 6 to 6:40 at 5 a.m. there was a lot of noise next door, and a fight, and loud talk, and some scuffling. It was kind of serious. I was worried that somebody was going to get hurt. I was about to call the police, but the noise ceased. The box in our locker, our basement bin, there's about 7 columns, and maybe 6, and there's about 8 rows, no, maybe 5 rows. And the box on the bottom of one of the columns was buckling because of all the weight, because it's heavy files, and it was a 1989 file box. And so we took the box out and then put in a brand new box. 7 a.m. there was more noise from across the hall. I found the green sock and the navy sock, and 2 cars were parked in 3B again. You saw that on videotape, and it is not fair. The noisy 3B car made 16 maneuvers in parking area and with a noisy radio, and at 9:45 a.m. Sunday morning, New Year's morning, I videotaped the 2 cars in one space, and at 9:45 a.m. Roberta blew her horn twice under our dining room window, and there was the cigarette smoke in the hall, and that's very, very bad, because secondhand cigarette smoke is terrible for a person to inhale and dangerous to his health. At 8:03 p.m. there was 6 horn blasts by, this is on New Year's Day, 6 horn blasts by Daniel Walsh as he drove the red truck into the yard under our dining room window. And when Daniel Walsh went by the door of Glendora, he mocked, "Glendora!" And Roberta slapped Glendora's door, apartment door, and activated the door knocker. They must have been under the influence of some substance, because normal people just do not act that way. The second petition, which I read to you last week, to John Porzio to evict James, Roberta, and Daniel Walsh, and Nella and Theo Alpucci, was served on John Porzio around about Tuesday, a couple of days ago. We haven't heard from Judge Ingracia about videotaping the induction of the judges, nor about Diva Segretti and the minutes that she promised to do for $30 and then up. Terrible for a person to inhale and dangerous to his health. At 8:03 p.m. there were 6 horn blasts by, this is on New Year's Day, 6 horn blasts by Daniel Walsh as he drove the red truck into the yard under our dining room window. And when Daniel Walsh went by the door of Glendora, he mocked, "Glendora!" And Roberta slapped Glendora's door, apartment door, and activated the door knocker. They must have been under the influence of some substance, because normal people just do not act that way. The second petition, which I read to you last week, to John Porzio to evict James, Roberta, and Daniel Walsh, and Nella and Theo Alpucci, was served on John Porzio around about Tuesday, a couple of days ago. We haven't heard from Judge Ingracia about videotaping the induction of the judges, nor about Diva Segretti and the minutes that she promised to do for $30 and then upped it to $40, which is wrong. You're not supposed to do things like that. And this is in the courts. This is mailing number 113. This is this week's mailing, and it's what happened on the week of January 2nd. It's Exhibit Theta Theta, and we have here 2,283 pages of Walsh, Alpucci, and Larkin lawbreaking. And we have 1,612 tortious acts by these people, and it was 44 degrees on Monday, rain. We've had no snow yet. Isn't that terrific? At 4:30 p.m., James Walsh broke three laws, roller skating back and forth by our south bedroom window 10 times. Glendora put up the sound pillow to block his noise. At 4:40 p.m., he gave up. 1, he broke the White Plains Noise Ordinance. 2, intent to alarm and annoy. A steady campaign, no legitimate purpose, that's harassment. Part 5, intentional infliction of emotional disturbance. That's the 3rd law he broke. It puts the tortious act up to 1,642. Franklin distributed the wall logs on Tuesday morning, January 3rd, to 13 apartments around about 6 a.m. That took a quarter of an hour. It took an hour yesterday to print the wall log, yesterday, Monday, and the cost was $5.40. Franklin also put out a reduced version of the John Porzio petition, the petition to John Porzio to evict Walsh and Alpucci. And the Glendora has decided to up the damages and make an amended complaint and increase the damages to $21,000 per family. Because it was $7,000 as of November the Armistice Day, 1993. But since they have continued the breaking of the laws and continued the injuries, I think they were about 700 or 800 tortious acts when the lawsuit was filed, and now it's doubled since they don't have the common sense to stop and live as they should live. The damages are going to be increased to $21,000 on the Walsh family, $21,000 on the Alpucci family, and $21,000 on the Larkin family for all that the lying, cheating Larkin lawyers are putting Glendora through. 7:12 a.m., the wall log was torn into 30 or so pieces on the floor. I showed you that on videotape between apartments 1A and 2A. Prime suspect would be Daniel Walsh. Here is the certificate of readiness for trial. If Judge Wood, the no good Wood Court, if he should be signing that and getting this thing on its way to the calendar clerk to schedule a trial, it'll be a year even there, sitting in the calendar clerk's office. So you try to find justice in these crooked courts, you're just not going to. Here are 12 a.m. law-breaking Daniel Walsh parks his car across the sidewalk, causing pedestrians to go into the road. The city of White Plains can be sued for that if the police don't come and do something about it. That's Tortious Act number 1643. The person who was too cowardly, whoever tore up the log, and whatever person had it strewn all about the hallway. It was too cowardly to own up to doing it. We will have to put names on the logs to block cowardly anonymity. Franklin notarized the grounds to evict on Tuesday, and it was served on everybody. BRS, who is a lawyer, and RP, who is a lawyer, we talked about increasing the damages to $21,000 per family. The Walshes were gone all day Tuesday. The mess is still in the front hall. The UPS man was reading a piece of it as he was delivering a package. The wall postage now costs $7. And we had to get new stamps, and the line was way out past the post office counters and into the post office lobby. That was true of the White Plains Post Office and the Scarsdale Post Office. It's just terrible the way they make people pay. We are now up to Wednesday, and the broken up log, torn up log is still all over the front hall. It looks terrible for anybody who comes in here. And we have here a police report. And this police report is written by Officer Eric Fisher, and it's about an event of December the 21st, 1994. The report taken over the phone. The complainant called and reported on the above date, time, and location. I can't read the writing. While the complainant was walking into her building, she heard Nala Alpucci of Building C, it's Building B, laughing loudly. Complainant felt this was aimed at her and was done to harass her. But the time of this was not 5:10 p.m., it was 3:10 p.m. And it wasn't Building C, it was Building B. Here is another couple of police reports. This report is about something that happened on December the 20th, 1994. The report is 2 pages. Report taken over the phone. Complainant reports on the above date, time, and place while she entered her building. An incident with a youth on roller skates. That would be James Walsh. That Daniel Walsh came out of the above building and frightened the complainant, and and stated, "You'd better run to your door." Complainant then stated Roberta Walsh then came down the stairs and screamed at the complainant, pushed her, and slapped her on the head. Complainant stated that Roberta Walsh also pulled complainant's hat off and threw it to the floor. The complainant stated she received no injuries during this. Altercation. No further incident was reported. This is number 43. I don't know what that means. Why did not Officer Glynn take this report and write it up as he should have? Because Glendora summoned the police to come and write up this report. And he just stood out in the hall. You remember all that. So that was very bad work, or lack of work, on the part of Officer Glynn. And that's everything on what happened on the law breaking of Walsh, Alpucci, and Larkin from December 29th, last Thursday, to 94, to January 5th, this Thursday, 95. And I want to tell you what page we're up to, 2,290. Now tomorrow, on the date, it's the return date, which is January 6th, and that is going out, and that was where Glendora shows cause that the Judge Wood Court has no jurisdiction over Farnham Walter Farnham, who's the CEO of General Accident, who is the insurance company for Daniel, for Kevin Larkin and Andrew Larkin, whose lawyers are that bad gang, Karamitsos, Comboy, Koza, Odell, McGrath. The court has no jurisdiction because Farnham is not a party to the action, and there's nothing in the CPLR that protects anybody who's not a party to the action, according to what they quoted, 6308 or 13 or whatever it is. That's for defendants, and they are not a defendant. So it was silly of Judge Wood court to sign such an order to show cause. He doesn't have jurisdiction. And the fact that they've got the wrong law. There's no law saying that you get a temporary restraining order against a plaintiff. It says you get it against a defendant. It's unbelievable what goes on in the courts. The ineptitude and the collusion and the corruption and the slowness. Shut the courts, lock the doors, put up a sign, out of order, close for repairs, and stop the sham. It isn't fair to kid the public that they're going to find justice in the courts, because they are not. The courts are too corrupt. Folks, there are so many labor-saving devices on the market today that you spend all your life working to pay for them. And the woman at the church said to the minister, they were having a rummage sale, and the woman was elated that she said, "You see that little room over there?" She says, "I sold everything in that little room." The minister said, "Good heavens, that's the cloakroom." And the reporter asked the two co-eds, "Why did you choose this college?" And the co-ed said, "Because of its rating." And the reporter says, "What rating?" And the girl said, 6 men to every 2 women. Folks, it took 4.5 hours to videotape what had happened that week. It was 2.5 hours of footage. There was a wind. It was still 40 degrees. We've had wonderful weather ever since August, and here it is January. The temperature was 40 degrees. TCI, Darrell and Franco did a good job, and they cleaned off some of the junk on the top shelf. We have quite a few more shelves to go, and I'm going to videotape that for you. And then I think we'll give them something like 2 weeks to get that place into order. We had programs 1643, 1644, 1645, 1647, and 16... That's it. 3, 4, 5, 6, 7, 5 programs. That's too much in a week. Too many programs to do in a week. Each one a half an hour. The Super VHS on television is beautiful. Have you watched TCI Channel 8 at 9 p.m.? It's done on Super VHS. It's fantastic. The texture and the color. It's great. I finished reading the CBS third quarter report. I'll read you a couple of facts out of that. Carl Davidson of Texaco. I just don't know about that man. I made a shareholder's proposal, and he lost it. And he said it turned up in the mailroom, and it turned up in public relations, and it turned up here and there. And I just said that he deliberately didn't want to see it. And so finally, he came up with that reason. You can believe it or not. I am still bothered by the ineptitude of the New York State Attorney General's office. I called up and I asked the woman 2 questions. I said, is the New York State Attorney General going to intervene on Glendora versus Cablevision in the Appellate Division, 2nd Department? And the woman says, "I don't know. I'm not involved." That's a public servant. That's a public officer. It's dehumanized. And there was an item on the news that two boys playing football in the Bronx, their football hit the police cruiser. They were playing football in the street or on the sidewalk just the way James Walsh used to, and that the policeman got so angry that he scuffled with the boy, and the boy ended up dying. And it was put down as an accident first, but now it's being put down as a homicide. That's how serious it is to play football in the sidewalk or in the street. I watch Keeping Up Appearances. I believe it's on channel 20 Friday nights at 8 p.m. It's a British comedy. It's pretty funny. It certainly is very well produced. Boy, those people work hard producing it. Detective Flanagan, I'm never able to get in touch with him anymore. Videotapes for Michael Gelman, who is the producer of Live with Regis. Evidence. It's been a heavy week of doing that, and it's really silly because the amount is only $120 for the videotape of mine that he lost and refused to do anything about. Favorite cable companies: Cross River, Purdy's, North and South Salem, Golden's Bridge. That's the United Video, and he takes up 4 programs, and Ed Gregory forgot to bring the 4 other programs that had been cable cast down from the head end. And that's about the 3rd time he's done it, and he said he would mail them to me, but he hasn't yet. United States Court of Appeals on Glendora versus Cablevision, Dolan, Tata, and all those people. That's the first lawsuit. Cablevision. No decision as yet. What are they trying to do? Get by without making one? I think UPS is a bad company to close down on the Friday after Thanksgiving and not give you any service. I think it's rinky-dink, and a woman calls up and says it's so their employees can have more times with their family. I say if they want more time with the family, give them all the time with the family. They have a duty toward the public. And what is his name? Kent something at UPS, and he's never there. Down in Atlanta, he's never there. No wonder the company is so bad. It's like Christmas was a beautiful day. No snow, no wind, sunshine, a little bit of rain and early but gone, and it was 39 degrees, and it was just beautiful like Christmas. You couldn't ask for better weather. And we had communion, of course. New Year's Day and Christmas were both on Sunday. And the first Sunday of the month we had communion, so you have a setup. You got a New Year, and you've got communion on the same day. So that's just perfect. 18 degrees this morning, but I went out and the Lincoln started right up. That's wonderful for a car that's 15 years old and has 200,000 miles on it. This Cablevision report is not signed. It should be. It's a fake thing. By William J. Bell as Vice Chairman of Cablevision Systems Corporation, Barry J. O'Leary as Senior Vice President, Finance and Treasurer, and Jerry Shaw as Vice President and Controller and Chief Accounting Officer of Cablevision Systems Corporation. Now there's 2 people I never sued. How did I miss those 2? And I am going to read you again, the Center for Judicial Accountability. Dear friend, thank you for responding to our October 26 advertisement on the op-ed page of the New York Times, reprinted in the November 1st issue of the New York Law Journal. There has been a tremendous outpouring of interest and concern from people all over the country. Many people are asking for help. Others are offering to help us. At this point, we are building a national citizens organization to deal with the problem of bad judges, judges who are incompetent and judges who are dishonest. Dishonesty means judges who knowingly disregard their ethical duties, disobey clear and controlling law, and who write decisions which fabricate or deliberately omit critical facts. Let me give you a list of my experience of those judges. Nikolai, Ruskin, Donovan, Fredman, Silverman, Colabella, Wood, Coppola. By such incompetence and misconduct, these judges destroy individual lives, families, and businesses, and for ulterior reasons, torpedo important cases in which the public has a vital interest. The financial cost of appealing a judge's bad decision puts appeal out of reach for the average citizen. Yet those who make the financial sacrifice and undertake appeal are often met with the same realities on the appellate court level as in the lower court level. Incompetent and corrupt judges create havoc at the trial level and overload the system with appeals. This puts the judicial system in crisis and is extremely costly to taxpayers. Obviously, improving the way we choose our judges is pivotal. We need judges of the highest competence, integrity, and judicial temperament. The origin of the center is rooted in this issue. We started in 1989 as a local citizens group challenging the manipulation of judicial elections by party bosses in the 9th